Alice and I are always looking to be more healthy, and we were just talking about how fasting is one of the best ways to do that, but it's so hard. But the great thing about Prolon is that's not what you're doing. It's not that you're not eating for 5 days. Instead, you're using their science-backed program to convince your body you're fasting.
You guys, this 5-day program really is amazing. It comes beautifully packaged and it does all the thinking for you. Each day is its own box. And by following their program, I know I just feel so much better. And I can't wait to experience Prolon Next Gen and continue to see results. For a limited time, you can be first in line to experience the new Next Gen at special savings. Prolon is offering the Prosecutors listeners 15% off site-wide plus a $40 bonus gift when you subscribe to their 5-day program. Just visit prolonlife.com/prosecutors. That's PROLONLIFE.com/prosecutors to claim your 15% discount and your bonus gift. prolonlife.com/prosecutors.
I'm Brett.
And I'm Alice.
And we are the Prosecutors. Today on the Prosecutors, we begin our discussion of Week 2 of the Derek Chauvin trial in the death of George Floyd. Hello, everybody, and welcome to this episode of The Prosecutors. I'm Brett, and I'm joined, as always, with my hard case co-host, Alice.
You're pretty hard case too, mate.
Oh, you saw the message too. Thank you. That's from Sarah, one of our fans from New Zealand, who had that suggestion for us. So thank you, Sarah. Introducing new words in our vocabulary. And Alice's wonderful New Zealand accent. She'll fit in just right if she ever decides to move down there.
So quick story about New Zealand. I have family who live in New Zealand, and I am from Texas, where there's a lot of vermin, all types of things that crawl, creep, and slide, and bugs. And I went to New Zealand, and my family members, they left all their doors open at all times. And I kept saying, won't the bugs come in? And they said, there are no bugs in New Zealand. I don't know if that's still true, but it was true when I went there a decade ago.
Really? Because, everything in Australia will kill you. So I just assumed that New Zealand had, all kinds of poisonous insects as well.
Maybe it's changed now, but it was utopia when I went.
Well, I've heard New Zealand is utopia. So, exciting news. Alice has moved. So, she is in a new podcasting closet.
I'm in a new closet.
It's her laundry room. A new closet. So, we are still working on the sound. So, if Alice sounds a little funky, that's the reason, because she has moved. So, congratulations to Alice. She has a beautiful new home. I visited it this weekend. It's fantastic.
Well, I think you all should know that the first things I moved over, I did not leave to putting it into a box. I brought over my podcast equipment so that it would be ready to record.
That is dedication. That's dedication. That's why we love Alice, because she's dedicated to this podcast. Thank you to all of you who've reached out about our Chauvin trial coverage so far. You've been awesome. We've been getting a lot of great comments and questions that we're going to try and continue to talk about as we go through week 2. So we're currently in week 3 of the trial. As a matter of fact, the prosecution just rested today. We're covering last week. As you know, we talked about week 1, and week 1 was a week that really started out with a lot of emotion. We saw some really heart-wrenching and difficult to watch video of George Floyd in the last moments of his life. And that was followed up by some sort of more technical testimony about use of force. This week is really going to be focused on a lot of that technical testimony, really drilling down to the central questions in this case. Remember, what we're talking about here, Chauvin has been charged with essentially 3 counts of unintentional murder in varying degrees of severity, depending on how bad what he did was. Was he negligent? If he was only negligent, that's the lowest form. That's manslaughter. All the way up to this second-degree murder charge if you think the activities he was engaged in were essentially a felony in of themselves. And that's what the prosecution's trying to show. On the other hand, the defense is trying to show some sort of reasonable doubt that Chauvin was responsible for what happened. And it can do that in one of 2 ways. The first way would be to show that George Floyd died for some reason other than what Chauvin did. So this is essentially the argument that Chauvin's just an unlucky guy. He just so happened to be involved in this incident with Mr. Floyd when other underlying conditions combined with drug use were putting him in a fatal situation. That's one way the defense could win if they could introduce some doubt about that. And the other way would be to say, look, even if what Mr. Chauvin did resulted in George Floyd's death, his actions themselves were in keeping with what a police officer can do. So think of it this way. And there was just an officer-involved shooting in Minnesota, so this is a raw subject. But it is true, there are circumstances in which a police officer can shoot and kill another person, and that is a justified action. We've all seen it. We know it happens. If in this case the defense could show that what Chauvin was doing, although it led to Mr. Floyd's death, was nevertheless justified, they could win that way as well. And so the prosecution's trying to show it wasn't justified and it killed Mr. Floyd, and the defense is trying to undermine that.
Before we get into week 2 witnesses, let's talk about some of the legal issues that were dealt with. One of the most interesting involved the man who was in the car with George Floyd the day he died and may have provided drugs to Floyd. His name is Morris Hall. The defense was eager to hear from Mr. Hall as they believed he could provide more information about the kind and amount of drugs that were ingested by Floyd. But unlike the prosecution, the defense cannot offer any kind of immunity to Hall for his testimony. And because of that, if Hall were to testify, and if he were to have provided drugs to Floyd, he could open himself up to criminal prosecution. Remember last week we talked about how there can be protections for a witness who testifies on behalf of the government to get some sort of a break on their sentence or some sort of benefit.
And it's interesting, the Fifth Amendment, and we're going to read the Fifth Amendment to you here in a second, but the Fifth Amendment protects you from putting yourself in danger of being tried for something. So if you want to assert the Fifth Amendment and the state comes in and says, we grant you immunity, you are now immune. We cannot prosecute you for that. You can no longer assert the Fifth Amendment because you're no longer testifying against yourself. So if this were the prosecution who wanted him to testify and they thought that his testimony was critical, they could offer him immunity. Obviously, the defense can't do that, and the prosecution's saying, we're not going to give him immunity.
Now, if the defense is correct in their assertion that the drugs and not the knee is what killed Floyd, then it might be Hall and not Chauvin who was responsible for Floyd's death. Now, as Hall's defense attorney said, there is an allegation here that Mr. Floyd ingested a controlled substance as police were removing him from the car, a car, by the way, that had been searched twice, and drugs have been found in that car twice. This leaves Mr. Hall potentially incriminating himself for prosecution for third-degree murder. Now, that's no light allegation there. So because of this potential danger, Hall invoked the Fifth Amendment, which reads, No person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury, except in cases arising in the land or naval forces or in the militia, when in actual service in time of war or public danger. Nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb, nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation.
There's a lot going on in the Fifth Amendment.
A lot of things that you all know, and you may not have known that they are all contained in the Fifth Amendment. You heard public takings or takings law. You heard double jeopardy. Right, double jeopardy is obviously a big one, that you can't be tried twice for the same crime. The prosecution gets one bite at the apple, not two. But the important thing here for Hall, what he's invoking, is that he doesn't have to say anything incriminating to himself, because we should all, what the Fifth Amendment affords all of us when it comes to criminal prosecution, is the presentment or indictment of a grand jury. And the grand jury is made of your peers who find that there is probable cause for the prosecution to bring a charge. In other words, it's a jury of your peers to check the prosecution so that the power to bring charges against individuals does not lie with the prosecution alone.
And I saw somebody trying to explain why we have the right not to testify. And it was such a terrible, he talked about like having this private space that you should be able to live in. And it was such an awful explanation of the Fifth Amendment. I just wanted to briefly touch on this. The reason you have the Fifth Amendment is because we have this adversarial process where the prosecution is responsible for bringing the evidence in. And if they don't prove their case, they lose. You don't have to say a word. It's all on them. In the British system, and they don't have this anymore, but in the British system, it was much more inquisitorial. Think of like Grand Inquisitors and the Spanish Inquisition and that kind of thing. They called them star chambers in the British system. And essentially they drug you in and they didn't have to put on anything. They asked you questions and you had to answer them. And if you didn't answer, they could hold you in contempt. And it was perceived as this very unfair system. So when the Constitution was written and the Bill of Rights was ratified, one of the things people were concerned about is they wanted to prevent that from ever happening. And that's why you have this right not to testify. And that's what Hall is invoking here.
Now, one thing that will be interesting to see is if Hall does not testify, how much can the defense use that to their advantage?
And I don't know the answer to this. I'm interested. Do you know the answer to this? Because one thing we can't do as prosecutors, let's say like two people are accused of robbing a bank, and we're prosecuting one of them. You can't call the other one, put him up on the stand, ask him, did you guys rob the bank? And he invokes the Fifth Amendment. Because everybody knows if he's invoking the Fifth Amendment, it's because the answer is yes, right? And if the answer is yes, then that incriminates the defendant. So we can't do that. If he's going to invoke the Fifth Amendment, he does it outside the presence of the jury. And we can't use that fact against the defendant. This is a weird situation where the guy who's invoking the Fifth Amendment, his testimony might actually be helpful to the defense. So I don't know if the defense can bring up the fact that the guy who was in the car with Mr. Floyd is refusing to testify.
I think it depends, right? So I don't know what the defense hasn't gone yet, so I don't know, but they can subpoena him. And what would happen is he actually has to invoke the Fifth Amendment. So he doesn't just not show up. He actually has to get on the stand, be sworn in, and under oath invoke the Fifth Amendment. And there are questions you can still ask. There are lots of strategic reasons you would not want to take the testimony of someone who wants to invoke the Fifth Amendment. They will not be a willing witness, nor will they try to be helpful to you. So there are lots of strategic reasons that even if you can ask questions that don't implicate the Fifth Amendment to someone, that you may not want to, knowing that they want to invoke the Fifth.
So my understanding on this is that the defense has submitted to the judge the questions they wanted to ask him if they were allowed to call him. And I think at this point, the judge has said, if those are the questions you're going to ask, you can't call him. because he's invoking the Fifth Amendment.
See, I find that so the reason I brought that up, Brett, is I find this really difficult because I think if they were able to call him to the stand and then first question out of the box, what's your name? I invoke the Fifth Amendment. And the judge allows that. And then he gets off the stand. I think you can make use of that in your argument. I think you can say, we called Mr. Hall to the stand and you saw that he invoked the Fifth Amendment, which is typically how the Fifth Amendment works. You have to invoke it rather than essentially having someone else invoke it for you, which is kind of the court in this case. So if that were the instance where the jury knew that he'd been called and he invoked the Fifth, I think they could make use of that. But if he just doesn't show up at all, there's typically jury instructions that apply to defendants about invoking the Fifth Amendment and how you cannot take silence as an admission of guilt. But again, like you said, the jury instruction is geared towards the defendant, not a third party who is not indicted.
And in this case, he's appeared in court. He's just appeared outside the presence of the jury to have this debate, this conversation with the judge. And at this point, it seems pretty clear to me the judge is not going to allow him to testify. Now, today, and we'll just go ahead and talk about this because we're talking about this. This is the beginning of the third week of trial where we're currently at as we record this. And this morning, they actually had a discussion about whether or not the defense could introduce the statement that Mr. Hall gave to police when he was questioned. And the basis for this, normally a statement given outside of court for the truth of the matter asserted is hearsay. That is classic hearsay. So, you call the police officer on the stand and you say, didn't Mr. Hall tell you that he gave George Floyd drugs? Objection, hearsay. And it is hearsay because it's outside the court and it's for the truth of the matter asserted here that Mr. Hall gave Floyd drugs. But there is an exception for an unavailable witness if the statement is against penal interest and is otherwise reliable. Here, Hall is now an unavailable witness. He is unavailable because he has invoked the Fifth. He cannot be called. So he could be sitting in the courtroom watching the trial, and he's still unavailable because you can't put him on the stand. He has this statement that he gave to the police. In that statement, he said that he gave drugs to Mr. Floyd, thus implicating himself in at least drug distribution, and as his attorney said, possibly third-degree murder. That seems to be a statement against penal interest. The prosecution argued today that it wasn't reliable because he also lied in other parts of his statement. So the judge has not ruled on that yet, as far as I know. He said today that he was going to take it under advisement, and I never heard him rule on it. But it'll be interesting to see how they end up dealing with this question in the end. So one other question that we were asked as a follow-up to our first week was about jury selection, and it was what would the two sides be looking for in jurors? And I actually thought this was really interesting because what they are looking for is the exact opposite of what they might normally be looking for. So in this case, the prosecution in jurors is probably looking for people who don't really trust the police, who believe that there is a need for widespread police reform, who don't trust, the state, who maybe think that there are too many laws and too many things criminalized, maybe are more of a liberal bent in their politics. Ordinarily, that's what the defense would want. And the prosecution would want what the defense wants in this case, which is someone who believes in the police and backs the police and believes in, really strict law and order and thinks if you break the law and something bad happens to you, well, you know what? The whole play stupid games, win stupid prizes thing, right? So it's really interesting because in this case, the two sides for jurors are really kind of looking for the opposite of what they would normally look for in sort of a typical criminal case.
Yeah, and we talked about, you have to make these decisions relatively quickly. There's typically jury questionnaires that go out ahead of time where you answer a slew of questions as we discussed last time. But then once you're in the courtroom, the questions start going really quickly because there are so many people. So oftentimes there's an entire profession called jury consultants who come in. They usually have psychology backgrounds and try to read how people would react in certain situations based on answers. None of us are experts, although we have to do it relatively frequently. But this is an interesting kind of change in what the characteristics of a juror each side is looking for at this time.
Yeah, usually The prosecution would want someone who believes the state's experts and thinks that hired outside experts are suspect. And in this case, the prosecution wants the jury to believe the outside experts and to discount their own experts. So it's funny how dramatically reversed the ordinary roles are in this case from what you would normally expect. Personally, I kind of think jury consultants and all that stuff is a pseudoscience. I think it's hard to know or tell, but plenty of people who would disagree with me on that. Well, let's get into it. Let's talk about the witnesses that took the stand in week 2 of this trial. So as we said earlier, week 1 started with emotional testimony from witnesses who were there, who personally saw George Floyd's death, many of whom recorded it, many of whom are haunted by what they saw. But it ended with something that I think is even more powerful. Testimony from Lieutenant Richard Zimmerman that what Chauvin did was, quote unquote, totally unnecessary, that it was, quote, uncalled for, and that he saw, quote, no reason why the officers felt they were in danger. For me, it's that kind of testimony that really matters. We've all seen the video. We've all been affected by the video. But where this case will be decided ultimately is on questions like that, questions that Zimmerman attacked directly, the actions that Chauvin was taking, whether or not they were reasonable. In week 2 of the trial, the prosecution is going to continue to chip away at the defense's argument that Chauvin was acting reasonably, given the circumstances. But first, they talked about what caused George Floyd's death, calling Dr. Bradley Langenfeld, the duty doctor when Floyd arrived in the emergency room, as their first witness for this week of trial. Langenfeld was interesting. He looked like he would rather be anywhere but in court. According to Langenfeld, when Floyd arrived in the hospital that day, his heart was not beating and they were unable to restart it. When Langenfeld looked for a reason for this, hypoxia, or a lack of oxygen in the blood, was at the top of his list of possible causes. According to Langenfeld, Floyd had extremely high levels of carbon dioxide. The prosecution ended by asking the doctor what the cause of death for Floyd would be if this supposition was correct, to which he responded, asphyxia. Now, I was critical of the prosecution and their opening argument, where they really focused on this lack of oxygen as a reason for George Floyd's death. And in this week, you're going to see all of the testimony that they lined up for people like me who thought, well, I don't know, your own expert said it was a heart attack, so maybe it is. And this is the first one, the first doctor who says, I think this was a death caused by asphyxia. This was powerful testimony, and it strongly supported that prosecution theory, but the defense was able to muddy the water on cross. So the initial CO2 level was 100, whereas a healthy individual would expect between 35 and 45. The defense was able to elicit testimony that fentanyl also leads to high CO2 levels. And in fact, the primary reason fentanyl is such a dangerous drug, and we all know how dangerous it is, and this doctor testified to that danger, is because it leads to such high levels of CO2. Shortness of breath is also a symptom of fentanyl use, and the defense was able to elicit testimony that no one administered drugs, whether it was the ER doctor, the EMTs who reported to the scene, none of them administered drugs that would have reversed the effects of fentanyl. This was a good cross, I thought. I talked about how in the first week I thought the defense was really on its back foot. I thought at the beginning of week 2, the defense kind of came out swinging on cross-examination to really hammer home this idea that they believe that it was drug use and not Chauvin's actions that caused Floyd's death.
Right, Brett, I agree. This was a very strong cross because it ends with the same outcome, which is the CO2 level, but gives the jury another path of how the CO2 level was reached. So far, they've only heard one story, which is the asphyxia answer. And here we have a potential external factor, fentanyl, that may have caused the CO2. Next, the prosecution pivoted back to the actions of Chauvin and called the chief of the Minneapolis Police Department, Chief Madeira Arredondo. After a lengthy description of the chief's history and jobs he had in the department, the prosecution moved on to Chauvin's training, the department code of ethics, and the policy manual. Prosecutors spent a large period of time on policies requiring de-escalation. They also talked about the requirement that officers provide medical assistance while waiting on emergency services, something it does not seem that Chauvin or anyone else did here. The prosecution also elicited testimony that neck restraints were only to be used in serious situations of active resistance that endangered others, not for mere passive resistance. After several hours of testimony, the prosecution finally shifts to the incident itself. So a quick note here, when you listen to trial testimony, it can be dry at times because of everything that they have, whether it's laying foundation or all the background they have to do. To spend several hours on all of the background for codes of de-escalation is going back to the prosecution shelf that they built. Remember, they are aligning themselves with the police. And this is what hours of testimony with Arredondo is doing. They're saying, let's turn back to what wasn't done here. Having Arredondo come in, who is the chief of the Minneapolis Police Department, talking about all of his experience and the training that any good cop, and I say good because remember they're saying that police are generally good, and if he had done the right thing, then Floyd would not have died.
And, you talked about in last week's episodes about the defense trying to take a sledgehammer to that bookshelf that the prosecution had built. And this is, the prosecution kind of coming back and rebuilding that bookshelf a little bit. The defense is trying to say everything he did was consistent with Minneapolis Police Department procedures. And here you got the chief coming in and saying, look, I know what the procedures are. I got all this training. I've been doing this for a long time. And what he did is not consistent with the procedures.
Now, the chief says that when he first saw the video from a city camera, he didn't think there was much to the incident. But then he saw the cell phone video. After establishing that the chief has now seen all the videos, the prosecution walked through the various policies about use of force. He stated that Chauvin's actions did not comply with department policies, including about de-escalation and neck restraints. The chief said that once Floyd stopped resisting, and certainly when he was in distress, the use of the restraint should have stopped. But the chief did admit that there was, quote, initial reasonableness in the actions of the police. This is something the defense will seize on. So when it's time for a cross-examination, the defense began by noting that it had been years since the chief had walked a beat. The defense also elicited testimony from the chief that it's not uncommon for individuals who are being arrested to say things to prevent the officers from taking action. Things like not being able to breathe. The chief also admitted that approaching a vehicle is one of the most dangerous things an officer can do. The defense drug the chief down into a discussion of Supreme Court jurisprudence on what is a reasonable person and what is a reasonable officer and use of force in escalating situations.
Yeah, and this is another place where I thought the defense did a pretty good job. One thing that I think is interesting about this case, and it's become pretty clear to me at this point, the prosecution is not going to argue that the initial use of force in this case was improper. So, we see use of force cases all the time where it seems like from the very beginning, the use of force is improper. You see somebody who doesn't seem to be resisting, and yet the police are just kind of losing their minds. And those are really some of the worst cases you see. Here, everybody seems to agree, okay, initially, when the police were trying to arrest Mr. Floyd, he did provide some resistance, and so some sort of use of force was appropriate. And it's really at that point where the question comes up. And this is good for the defense because it's good for the defense to be able to say, well, isn't it true that what Mr. Chauvin did at the beginning was entirely appropriate. Yes. Isn't it true Mr. Floyd was resisting? Yes. He's getting that from these prosecution witnesses. So it's not quite as black and white as, the 9 minutes and 29 seconds, which once again, we talked about. The prosecution, they really want you to focus on those 9 minutes and 29 seconds. And the defense has been saying, look beyond that, look before that, look at all this other stuff. And this is sort of their effort to do that. And part of that you're seeing here, because you have the chief who's having to admit that, and you have the chief who's having to say, yeah, it's been a while since I've been out there. And this conversation about what is really some complicated stuff. And I kind of feel like this is almost reasonable doubt through confusion. If you can confuse the jury enough so the jury's like, man, I have no idea what it means to be reasonable, that's doubt in of itself, right? Like if the jury doesn't know what a reasonable officer should be doing, then how can they convict somebody? And the reasonable officer standard is governed by a case that comes up over and over and over again in this trial called Graham versus Connor. And the Supreme Court, it's the Supreme Court case in the United States, established what is called the objectively reasonable test. And here's what they said. With respect to a claim of excessive force, the same standard of reasonableness at the moment applies. Not every push or shove, even if it may later seem unnecessary, in the peace of a judge's chambers, violates the Fourth Amendment. The calculus of reasonableness must embody allowance for the fact that police officers are often forced to make split-second judgments in circumstances that are tense, uncertain, and rapidly evolving about the amount of force that is necessary in a particular situation. And you see the defense counsel bringing this stuff up over and over and over again with prosecution witnesses, talking about the evolving situation, talking about how tense the situation is getting with the crowd that's getting more and more unruly, talking about how the officers are having to make these very quick judgments about how much force is appropriate here.
Shopify is a platform built for growth, whether you're just starting out or already running a thriving business. From managing inventory to creating a seamless checkout experience, Shopify is designed to handle it all. And it doesn't stop there. Shopify helps you sell everywhere your customers are, online or in person. It's the ultimate tool for turning big dreams into big wins. Sign up for your $1 per month trial period at shopify.com/OPP.
Okay, so the Supreme Court goes on and says, as in other Fourth Amendment contexts, however, the reasonableness inquiry in an excessive force case is an objective one. The question is whether the officer's actions are objectively reasonable in light of the facts and circumstances confronting them, without regard to their underlying intent or motivation. So this is another thing. It doesn't actually matter. Now look, if Chauvin's intent was to kill George Floyd, that would obviously matter, and he would be charged with first-degree murder. The prosecution's already conceded he didn't intend to kill George Floyd. And so what the Supreme Court is saying here is, at that point, it actually doesn't matter what he's thinking. It doesn't matter what's going through Derek Chauvin's mind. I know that's hard to wrap your head around, but this whole reasonable test is, would any officer, no matter whether they're a good guy or a bad guy, if they would do the thing that was done, then it's objectively reasonable. And this is what the court says about it. An officer's evil intentions will not make a Fourth Amendment violation out of an objectively reasonable use of force, nor will an officer's good intentions make an objectively unreasonable use of force constitutional. So it's all about this objective standard. Would a reasonable officer in Derek Chauvin's shoes that day do what he did? Now, how in the world do you know that? Well, the court said, we're going to give you some factors to consider. So when you're trying to figure out whether or not it's reasonable what happened, here's the factors to look at. Proper application requires careful attention to the facts and circumstances of each particular case, including the severity of the crime at issue, whether the suspect poses an immediate threat to the safety of the officers or others, and whether he is actively resisting arrest or attempting to evade arrest by flight. And those factors are going to come up again and again and again as we listen to these witnesses, and we'll probably come back to them as well.
Now, with this standard in mind, the defense forced the chief to acknowledge that what is reasonable should be judged by the situation at the time without benefit of hindsight. The defense also began to bring out a theme of its case, that it may be necessary to use force against one person to prevent another person from taking action. This idea that the crowd was growing angry and that led to the police continuing to apply force to Floyd. The defense also brought out that the officers had discussed the use of what is called the maximal restraint technique, but then decided not to, indicating that the officers were evaluating the situation and adjusting their force appropriately. And the defense was able to elicit testimony that other videos seemed to indicate that Chauvin's knee was not on Floyd's neck the entire 9 minutes, as it appears from the famous video, but that at some point his knee had shifted to the shoulder, a fact not evident from the main video. Now, we've talked about how the prosecution goes first, and then once it rests, the defense goes. But as you know, because the best story wins and the prosecution goes on for weeks, the defense has to start telling its story. But how does the defense tell its story if it is not its case in chief? You have to start telling the story during cross-examination, which the defense, I think, begins to do here effectively. Now, on redirect, the prosecution pressed that this was towards the end of the restraint and that the knee likely was on the neck until the very end of the encounter. The prosecution then moved on to a number of training officers, including Sergeant Kerr Yang, to discuss training they received. Yang spoke about crisis training and that officers were trained to reevaluate a developing situation as it went on and to provide medical assistance when necessary. On cross-examination, Yang was asked about the growing hostility of the crowd. Yang acknowledged that the interactions with the crowd was one factor to consider when evaluating use of force, and that the risk to the officer could increase because of growing restlessness in a crowd. What you're beginning to see here through these two witnesses we've discussed is that back and forth that we talked about, that imagery we gave you last week. Prosecution building up their bookcase and the defense doing everything it can to break down that bookcase, and then on redirect trying to build that bookcase back up. It really is a ping pong back and forth, and the way their questions are shaped for each side is really through the lens of the way they want the jury to view the case.
And I think the cross-examination of these witnesses and the next couple witnesses are really the best work the defense has done up to this point. You can really see them. Whereas in the first week, it just didn't feel like they were making any headway. It just seemed like they were getting killed. And this week, as you got into this more technical stuff, and technical stuff like this is always going to have two sides. I mean, use of force and what the manual says and what's reasonable and all this kind of stuff. There's always going to be sort of another side to it. And I feel like the defense did a really good job of pushing back on some of this narrative that the prosecution was building up.
Johnny Mersel was next. Mersel helped develop the training program that Chauvin took part in. He said that officers are always trained to use the least amount of force necessary to bring a situation under control. Prosecution showed him a photo of Chauvin, and he testified that the technique is not currently and has never been authorized as a restraint technique taught by the Minneapolis Police Department. He said, quote, "We tell officers to stay away from the neck when possible." But Mersel's testimony was not as straightforward as it first appeared, because what he just said is pretty devastating. Now, on cross, Mersel was shown a different photo with Chauvin's knee in the area of Floyd's shoulder blades. Mersel confirmed this was an approved technique. The defense also elicited testimony that these kinds of ground holds were introduced to prevent officers from having to strike subjects to bring them into control. Mersel also testified that officers are allowed to maintain a neck restraint to keep someone unconscious because upon reviving, suspects can be even more violent than they were before the restraint was applied. The prosecution also called the medical trainer, who confirmed that Chauvin has received that training. Now, on cross, the defense continued to build its case that fentanyl had more to do with Floyd's death than Chauvin.
So you can really see what the prosecution's trying to do and the defense is trying to do in these two witnesses. So you have these training officers who come in. One's the guy who trains you how to subdue people. One's the medical training officer who teaches you CPR or whatever. With the training officer wants to say, look, it's black and white. You never use this. We don't tell people to use this technique. You don't put your knee on somebody's neck. And then the defense is like, well, what about on their back? And he's like, well, okay, yeah, you do that. And you can sort of see how it's not that far from your neck to your back, and you can sort of imagine maybe Chauvin just didn't get very good training, or maybe this is an evolving situation and Chauvin's knee was higher on the back than it should have been. And the medical person comes in and says, look, he knew how to give CPR. He should have given CPR. And the defense is able to come in and talk about fentanyl and all the bad stuff fentanyl does. And this whole thing about someone who's unconscious, the defense beats on this repeatedly, that if someone is struggling and they go unconscious, that there is a phenomenon that when they wake up, they're even more violent than they were before. And he keeps pushing this like, isn't that something the officers would have known? Isn't that something they would have been concerned about? Could that be a reason they were trying to keep him unconscious? So, yeah, I mean, the defense is doing a better job. They're just doing a better job because there's a little bit more gray area that they can exploit. It's really difficult to exploit the video, the 9-minute and 29-second video of Mr. Floyd. Really hard to do that if you're the defense. And when they tried to do it, they ended up, stepping on a rake and smacking themselves in the face. But on these, it's a little bit better. At this point, it's interesting. At this point, the first expert witness testifies in this case. So there have been a lot of witnesses with sort of expertise, but this is the first one who is qualified as an expert. And this is Sergeant Jody Steiger, a Marine and 28-year veteran of the Los Angeles Police Department, who is still with the LAPD. At the beginning of his testimony, he notes that he is on vacation for this testimony, so he still works for the LAPD, but he's on vacation. He had reviewed all the evidence in the case, as well as the training materials of the Minneapolis Police Department, all with reasonableness in mind, that reasonable test we've been talking about. When asked his opinion, and this is the great thing about having an expert, because what you get to do is you say, so you've reviewed everything? Yes. Well, do you have an opinion within a reasonable degree of scientific certainty or medical certainty, depending on who you are, whether or not the use of force here was reasonable? And he gets to say, my opinion was that the force was excessive. And not only is it his opinion, but it's his expert opinion. And at that point, he walked through those factors we talked about earlier, the Connor factors, they're called, and found them utterly lacking in each case. Now, he acknowledged, and the prosecution's never denied, that initially Floyd was resisting officers, and that they were initially permitted to use force against him. But, and this is really important, once Floyd was on the ground and his resistance stopped, that is when the force should have stopped as well. Now, as we've talked about, acknowledging that the officer's actions were initially reasonable is a double-edged sword. It gives the witness credibility, since he isn't saying that the whole encounter was unreasonable, but in acknowledging that the officer's actions were initially reasonable, it does give the defense an opening to say that just because the officers didn't recognize in real time in a difficult situation that they should have decreased their initially lawful use of force does not rise to a crime. And that's basically what the prosecution has set themselves up to have to prove. By not saying that the initial use of force was unlawful, they have to say there is a moment when the officers should have known that whatever force they were using needed to decrease. And on cross, the defense attacks this. They have the witness acknowledge that reasonable minds and reasonable police departments could differ on what is objectively reasonable, which is kind of mind-blowing, but he asked the question, can different reasonable police officers have a different view on what's objectively reasonable? And the witness says yes. And it's kind of like, wow, okay. Like, well, what does it mean to be objectively reasonable then? I'm not sure. The defense also does a fairly good job of expressing how broad and sometimes unclear the reasonableness standard is and how officers must apply many different factors quickly. This may all sound like really complicated to you. I mean, as you're listening to this, you're probably thinking, man, this is, your eyes are rolling back in your head. You're bored to death. You're like, what is all these reasonableness factors? Well, just imagine these police officers are having to apply all of these things in real time while attempting to subdue someone. And that's what the defense is trying to really point out, is they are really in a difficult situation. And that, like I said, they're having to apply all those factors quickly. Now, here's the problem with this. And a problem that really gets worse and worse for the defense as they go on. The defense attorney keeps hammering this idea that this is split-second decisions. You got to make a quick decision. It's almost like the argument that's typically used when officers are involved in a shooting, that the decision whether or not to pull your weapon and fire it is a split-second decision, and it is really difficult to put yourself in the shoes of that officer and say that was unreasonable. The problem here is this was not a split-second decision. Here, the officers had nearly 10 minutes to make a decision. Now we'll go back to the 9 minutes and 29 seconds again. That's how long this lasted. It wasn't really a split-second decision, and I think the prosecution's going to do a good job later on of hammering on this, but the defense is not done. They also point out that Floyd was saying many different things before the police used force that appeared to be bargaining with the police not to arrest him. And one of those things was that he couldn't breathe. Mr. Floyd was saying he couldn't breathe before he went to the ground. He actually was saying that before they even put him into the back of the police car. That means he was saying he couldn't breathe before force was applied, and that, as the prosecution's already acknowledged, when force was applied at that time, when he was saying he couldn't breathe, that was a legitimate use of force. The defense also noted that he was preventing, while doing this, there were 3 officers trying to get him in that car, and he was able to prevent them all from doing so. And the defense was able to get this expert witness to acknowledge that even handcuffed, a suspect can still pose a danger. And then came what I thought was a bit of a bombshell moment. The defense plays a portion of the video. I think it was one of the body cam videos that we're really just seeing for the first time. And he plays a clip. And the great thing about being a defense attorney is you get to lead the witness. So you don't just ask them, what do you hear? You can say, do you hear this? And what he says is, do you hear Mr. Floyd saying, I ate too many drugs? Now, the witness can't make it out, but this is going to come up again later. Incidentally, the witness says that he was paid about $13,000 for his expert testimony.
There was a lot in that expert, Brett, and we'll come back to a lot of what he's said. The payment for experts often comes up. That's fair game question. You usually prep to be asked for it because the defense is trying to elicit how much they got paid so that it somehow undermines their credibility to the jurors. It's left up to the jurors what they think. Maybe $13,000 is a lot. Maybe it's not in their minds. That's a very good point you make, Brett, about how you can lead the witness on cross. And essentially in this case, what the defense counsel wants to do on cross-examination is be the one who's testifying. So even if he couldn't get Steiger to say, Floyd said, I ate too many drugs, the jurors have already heard that, and now it's in their mind. They didn't know that's what Floyd may have been saying, but now someone's put it in their mind that may be what Floyd is saying. Now, Special Agent James Ryerson testified next. He was the lead investigator into the criminal case against Chauvin. Ryerson explained the investigation. The prosecution direct was rather boring, actually, and for the purposes of simply introducing various pieces of evidence, what we spoke about previously, laying the foundation to get things into evidence. Ryerson spoke about finding a pill that tested positive for fentanyl in the squad car, which was probably the highlight of his entire testimony. But then on cross, it got really interesting. The defense played the quote, "I ate too many drugs" clip for this officer as well. Because the rule had been invoked, and the rule means that no other witness can be in the courtroom as another witness is testifying. And that's just to prevent any witnesses from copying or corroborating another witness's testimony to try to bolster another witness's testimony. So the witnesses are kept outside of the courtroom. They don't know what previous testimony has come before them. Now, that means that Ryerson did not know that the cross-examination already covered with Steiger the "I ate too many drugs" clip. So he is hearing this for the first time. When asked if he heard, quote, "I ate too many drugs," he replied, yes. On redirect, however, the prosecution asked him if after listening to the video again, if he heard something else. He said he had listened to it on break, and he now believed that Floyd said, "I ain't do no drugs." After this testimony, a forensic scientist testified that the pills found contained methamphetamine and fentanyl. Floyd's DNA was also found on pill pieces containing methamphetamine. The methamphetamine was actually pretty crappy. It was less than 3% pure meth. Nowadays, you could buy almost completely pure meth, 96 and above percent pure meth. So this was actually very low quality meth.
Yeah, I don't know where he got this meth, but that's really bad meth. But I guess maybe the fentanyl was the main thing, and the meth was just part of it. This testimony from Ryerson is really interesting because once again, the defense is trying to say this is all drugs, and they're trying to say that Floyd essentially, when he was being arrested, he ate drugs. He put some drugs in his mouth to hide them, and he ate them. And then if he's saying, "I ate too many drugs," it's almost evidence that he recognizes he's having some sort of overdose. And I don't think the prosecution anticipated this. Their first person was asked this, and he said, I can't make it out. When I listened to it, I heard "I ate too," but I could not figure out the rest of it. And then they bring this guy in, and once again, he's testifying cold. He doesn't know that this has come up. The defense plays it for him, and he's like, yeah, that's what it sounds like. Very fortuitous break happens at that point. So there's a break after the defense's cross-examination, which a lot of times there's not a break in the middle of a witness, but in this case there was. And I can only imagine the prosecution grabbing this guy and throwing him into a room somewhere and saying, "You listen to that tape until you can say it says something other than 'I ate too many drugs.'" And the prosecution, when they put him back on the stand, they play an extended clip of the conversation. And in context, it makes more sense that Mr. Floyd would have been saying something along the lines of, "I ain't do no drugs," because the police are asking him about that. So that makes more sense. And that's what Ryerson now says he heard. But it certainly was an interesting sort of point in the testimony and in the case that the prosecution was presenting. So I think this is the high watermark of the defense. I think this is the best moment for the defense. I think the defense has done a pretty good job in these early witnesses undermining the prosecution's case. And that's where we are going to stop today. But tomorrow, we're going to start with the testimony of Dr. Martin Tobin. And this testimony was some of the most amazing testimony I have ever heard. And I really believe that this trial really took a turn when Dr. Tobin testified. So we're going to talk about that more tomorrow. We'd love to hear your thoughts, questions, comments. Shoot us an email at prosecutorspod@gmail.com. Look us up on Instagram, Twitter, Facebook at prosecutorspod. Check us out on Reddit. Join us on Patreon. Go see our friend Sirius Moonlight on Instagram, who does all the artwork for our cases, including the artwork for this one. Keep leaving those reviews, those 5-star reviews on Apple. Thank you so much for all those. And please do check out our sponsors, Daily Harvest, BetterHelp, and Pretty Litter. Check out those sponsors. Support those sponsors. They support us, and we want you to support them. Well, Alice, do you have anything else you want to add before we sign off for today?
No, this was jam-packed. This was very heavy on the law. So keep asking us your questions. We're here to try and, again, give you a clear view of what is happening, the facts of what's happening. So come back tomorrow for some riveting testimony.
Yeah, sorry if it's been a little dense lately, but we are trying to pack an entire week of hours and hours of testimony into a couple episodes, so just give you the highlights. In any event, we will be back tomorrow with more testimony in this case, but until then, I'm Brett.
And I'm Alice.
And we are the prosecutors.
I'm going to talk normal. Normal Alice.
Normal Alice. Just normal Alice.
Okay.
You just get quiet. You know,
I'm
you just
sorry.
get quiet.
I just get
It's
so
okay.
thoughtful.
I know, you're so thoughtful. It comes
I'm
across.
sorry.
It comes across. You're just so thoughtful. Okay. Okay, so this is week 2. Inquiry in an excessive... The reasonable... However...
If you're looking to streamline your audio advertising buys and maximize your revenue, look no further than Triton Digital's programmatic audio advertising exchange, A2X. The private exchange consists of only licensed broadcasters and top-tier internet radio publishers, assuring the quality inventory and brand safety you can trust. Visit www.tritondigital.com to learn more.